Brennan v. Burdon and others, London Borough of Islington, Leigh and Co. 2004. The claimant sought damages for injury alleged to have been suffered as tenant of a house after being subjected to carbon monoxide poisoning, and also from her former solicitors for their delay in her claim. The effective question was whether the compromise of proceedings entered into by the parties on the basis of a common mistake of law was void by reason of that mistake. At the time of the agreement, the condition of the law suggested that an appeal would be unsuccessful. The CA in Anderton v. Clwyd later reversed the postion. The established principle was that a mistake of law common to the parties could not vitiate a contract. That law had developed. 1. As with any other contracts, compromises or consent orders may be vitiated by a common mistake of law. 2. It is initially a question of construction as to whether the alleged mistake has that consequence. 3. Whilst a general release executed in a prospective or nascent dispute requires clear language to justify an influence of an intention to surrender rights of which the releasor was unaware and could not have been aware. Different considerations arise in relation to the compromise of litigation, which the parties have agreed to settle on a give and take basis. Huddersfield Banking. For a common mistake of fact or law to vitiate a contract of any kind, it must render the performance of the contract impossible. The great piece. This was not a contract which would be impossible to perform. So important is the principle of seeking to uphold contracts of compromise that in my view the court should not permit them to be reopened for mistake of law created by the retrospective impact of the declaratory theory of judicial decisions, except where, for some truly exceptional reason, justice very clearly demands